Intended to be for informational purposes only. The information does not constitute legal advice. The law constantly changes. The information may not be complete or correct depending on the date and your particular legal problem. Each legal problem depends on its individual facts, and different jurisdictions have different laws and regulations. Because of that, you should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. And he is Marshall Chriswell. Good morning.
Good morning.
It's good to have you with us here today. There's so much that happens in the month of August. It's a really active month with a number of different things, and you're transitioning into fall. But one of the things we want to refocus on is the fact that this is National Make a Will Month. And so today we want to talk a little bit about making a will and its importance, particularly if you have minor children. So let's start with that.
Sure, yeah. This is the time of year, August, whenever we you want to talk about this all year, but August is a month especially designated to, thinking about estate planning issues, and it is Make a Will Month. And like you said, if you have minor children, it is really, really important that you sit down with a lawyer and think about creating a will. And it's actually, when people have kids, a lot of times that's the first time that someone really thinks about, I may need to put these plans in place. That's when a lot of people start thinking about creating a will. And one of the reasons that it's so important is your will is the document where you're going to state your intention for who is going to take care of your children in the event that you and your spouse pass away, or if you're a single parent, if you pass away, you can state your intention for who would be the guardian of the children's person, so someone to manage, someone to take care of the kids and perform all those parental duties that you do on a daily basis, and then also who would be a guardian of the children's estate, which is a legal term for who is going to take care of the money that you leave behind, or other property that you leave behind for your children.
Okay, so you, as we have told folks quite often in the past, that free consultation is really important to get to meet each other, get to know each other. What are some of the factors that go into a will for people who have minor children? What are the things they need to consider?
Sure. Well, of course, we're going to have a detailed conversation about the guardianship issue. And so in the will, you're stating what your intention is for who would serve as guardian of the person and guardian of the estate for your minor children. Now, it's important to understand that those decisions aren't binding on a court. Okay, whenever a parent or parents pass away and leave a child without a guardian, there always needs to be a court proceeding to make a final determination as to who is going to serve in those roles. But the intention that you state in your will is very, very persuasive to the court. And unless for some reason, that person is unable to care for the children or unable to manage their money, or the court, determines, well, they're just not, they're not responsible enough, something like that. Unless you have a pretty serious situation, that your intention is going to stand. So you really need to think about, who in your life that has a relationship with your kids, probably, who is best suited to take over those parental duties and have guardianship of the children, and potentially adopt them. So and when we talk about who is going to be a guardian of the person, performing parental duties, and who's going to be guardian of the estate, those can be different people, and that happens a lot. That once we really have this conversation and flesh out all of the different factors involved, the person comes to a determination that, maybe my sister or my aunt or a trusted friend is best suited to have the children in their care, but maybe they're not best suited to manage the investments that would be left behind in the event that I pass away. So those can be different people, and those are the kinds of things that we talk about.
Yeah, my goodness, there do seem to be a lot of issues, and I would not guess that it's all that common that what we see all the time in the movies, that there's a big court battle over the kids, that actually ensues. But you do need to make sure that intentions are clearly known. And it's probably a good idea after you make those determinations and come up with all of the paperwork and everything that's filed away that everybody is on board with this, that they know what the plan of succession would be.
Yes. As with all of the folks that you're putting in, roles in your estate plan, whether it's your executor, power of attorney, guardian, or trustee, you really, the best practice is to have a conversation with them to make sure that they understand that you've given them this job, and make sure that they're on board with it, because appointing someone that isn't going to accept the appointment when the time comes around is that's fruitless. So another thing that's interesting, in Pennsylvania, we have what's called a standby guardianship statute, which allows you to create a document that standby guardianship form, which appoints someone to serve as a guardian of minor children in the event that certain things occur. So, we've talked about power of attorney. If you become incapacitated, who's your power of attorney to take care of your, pay your bills and manage your bank accounts and your real estate and things like that? This is like a power of attorney for children, right? So the document can say if you become incapacitated, if you pass away, it can have all these different scenarios, these conditions. And it allows someone to immediately step in upon the occurrence of one of these conditions to care for the children for up to 60 days before a court would appoint a permanent guardian. So these documents are really useful as well to do in conjunction with a will, because in the event that, tragically, two parents pass away or a single parent passes away, leaves minor children that are not don't have anybody to attend to them, don't have anybody to sign medical releases or take them to the doctor or make decisions for school, things like that. This standby guardianship form, you can actually put this in place, have the same people named as guardian as you do in your will, and they can begin taking care of the kids immediately upon something happening to you, because it can take a little while to get into court, right? Yeah. So that's another kind of tool in our toolbox that we often use in these situations.
Yeah, is that common? With Pennsylvania has it. Is it common in other states?
It is. I don't know that every other state has a standby guardianship, but to my knowledge, the majority of states do.
Okay. Now, here's a question I have for you, and maybe not in a legal sense, maybe more in a common sense type of thing, but you'll have the answer to this. Are there different considerations when it's a younger child than if it's an older child who in a couple of years is going to be a legal adult?
Well, you still need to have the guardianship in place because, of course, if something happens before the child turns 18, there needs to be somebody to make decisions for them, and you want to be able to pick who that person is. The other thing is, often whenever we're creating a will for someone with children, we're putting trust provisions in place. So in the event that there are life insurance proceeds or whether it be real estate or significant bank accounts or investment accounts, we want to put trust provisions in place in the will so that, number one, if a child's under 18, a life insurance company or investment company is not going to write a check to an underage child, right? Mm-hmm. But even if they're over 18, there are, clients generally see the wisdom in withholding some funds in trust until a child is of an age that they have hopefully, reached full maturity and can handle those sums of money. So, even if a child's 15, 16 years old, we're creating a will, you still want to think about these issues because often we're putting trust provisions in place that are going to last until the child is 21, 25, and in some cases older.
All right. This is a very important question. I want to be sure we get it in before we're out of time. What happens if we don't do it? If we don't get that will and we have minor children?
Number one is that you mentioned a legal battle over custody of the children, and unfortunately, that is not uncommon, right? You have parents who die tragically in a car accident, and both families, there are people from both families that decide they want to raise the children and be, and manage the finances, and that automatically creates a legal conflict. So, by not having at a minimum a simple will with guardianship provisions, you are setting your family up for conflict at a time when people are grieving. They're going through that process and often not thinking in the most cogent fashion anyway, and then you're creating a legal dispute with your kids in the middle. And that's the number one thing that we try to avoid in all estate planning, right, is disputes among family members. We want to create clarity and certainty and avoid any of those issues if we can. So that's the number one thing that not having a will when you have minor children can avoid. The other thing is having the provisions in the will which instruct your executor or trustee or guardian of the children's estate on how to manage investments and who can do that and things is hugely important, because as I said, the investment companies, the life insurance companies, are not going to stroke a check to a minor child. They will stroke a check to an 18-year-old child, and those checks can be sizable. And even if it's even $10,000 or $20,000 is a lot to an 18-year-old kid, and certainly can be a lot more than that. So those are the considerations that if you don't have it in place, what harm could emanate from a child of that age getting those funds. So things like that.
All right, so making a will, obviously very important for everybody, but certainly when you have minor children, there are some extra considerations. So somebody wants to do that, they want to talk with you and have that free consultation. What do they need to do?
Sure, you can come see us at our office in the R&P building on Church Street in Indiana. Give me a call at 724-465-5826, or go online to www.westernpalawyer.com.
He is Marshall Chriswell. Thank you.
Thanks, Todd.
Have a great day.
You too.
Great day.
You too.
Great day.